So here's the issue that I have, Mr. Jones. Mr. Parker's argument that there's a drug issue. It's not a drug use issue. It's a drug dealing issue, which is what the underlying case had to do with as well. When you were pulled over for that and you got the case of the unlawful possession of a firearm by a felon, you were found in possession of the Glock 9mm with a chambered round, green marijuana in the center console, another bag in the cup holder, and then another 4 bags and a scale and a second firearm in the car, again, chambered with rounds in it, another magazine under the driver's seat, and another magazine in the center console. Now, here we are. You get probation for that. And 3 weeks later, you're dealing drugs again. All right, you're Jason James. Okay. So Mr. Jones has 2 cases. We've got cause number 26, DCR 0340, which is a new offense of possession of a controlled substance, a 2nd-degree felony. And then we've got a motion to revoke, which is in cause number 23, DCCR 0390. And the underlying offense in that case is unlawful possession of a firearm by a felon. Looks like we were here. Initially, there were pleas of not true, and then in May, we came back on the motion to revoke. He changed his pleas to true to counts 1 and 2. We set a hearing today. The agreement is for a cap of 8 years in each of these cases. Is that correct?
Correct, yes.
Yes, Your Honor.
Okay, and he already pled guilty on the other one as well.
Yes, correct.
Got it. Okay, I have the original pre-sentence report from that unlawful possession of a firearm case, but I also have an updated report that was prepared. And have you all had an opportunity to review that update?
We have, Your Honor.
Yes, Your Honor.
Any additions or corrections?
None that I'm aware of, Judge.
Not mistaken.
I also have just looks like 3 pages of few incident reports. If you all had an opportunity to review those as well.
Yes, Your Honor.
I have.
All right, Mr. Parker, you may proceed.
Your Honor, we're asking that the court keep him on probation. He wants the opportunity to prove he can complete it. We're asking that you let him serve the ISF track cognitive to make him help better decisions. And also putting in the Chase DI program where he's tested regularly. And I mean, then it's, we know whether he's using drugs, but drugs has apparently been the problem on his underlying case. I think he wants to address the court, Judge.
Give me just a second, and then I'll let you do that. I'm printing a PC. Go ahead, Mr. Jones.
Yes, Your Honor. I've had time to reflect on what brought me here before you today. I take full responsibility. And if given a second chance to complete my probation, I just need a chance to prove to you, my family, my children, I can be not a liability to my community, but an asset. I had things going on before I got locked away and started a business, and I'm a single parent, getting my license and my diploma like you asked me to do. So
Okay.
just asking for another chance to get that done.
In just a second to review this, and then I'll let you go, Mr. Nichols. Mr. Nichols?
Judge, when we entered the pleas of true, it was right before we were about to have a hearing to prove up the new allegation. I'll summarize for the court what that would have shown. Back in June of last year, only about 3 weeks after he started probation, he was detained in an empty lot off of about a block off of Calder, downtown Beaumont. Not coincidentally, about a block also or two away from Henry's place. And what he had been doing was selling crack cocaine. He was one of several individuals in an empty lot that had an active trespass warning on it. And Beaumont police would have testified the reason they went to that lot and detained people that day was because they had received or been informed by several people that had been stopped that week with crack cocaine that they bought it from him. And so when he stopped, he's sitting in a lawn chair in this empty lot where he's not supposed to be with a plastic grocery bag underneath the chair. And in that chair is about 11 grams of crack cocaine along with synthetic marijuana and I believe actual marijuana. And so he had gotten probation for the charge of unlawful possession of a firearm by a felon. His original felony case was a state jail from Harris County. And then almost as soon as he's put on probation for that, he's in the street selling crack. I don't see how we would keep him on probation. I think 8 years is appropriate. On both these cases, Judge, it's a second degree amount. So the new case that he pled guilty to.
So here's the issue that I have, Mr. Jones. Mr. Parker's argument that there's a drug issue. It's not a drug use issue. It's a drug dealing issue, which is what the underlying case had to do with as well. When you were pulled over for that and you got the case of the unlawful possession of a firearm by a felon, you were found in possession of the Glock 9mm with a chambered round, green marijuana in the center console, another bag in the cup holder, and then another 4 bags and a scale and a second firearm in the car, again chambered with rounds in it. Another magazine under the driver's seat and another magazine in the center console. Now here we are, you get probation for that. And 3 weeks later, you're dealing drugs again. So it's not a matter of, I want to do better. It's you literally got probation and 3 weeks later, pretty much just thumbed your nose at me and said, I can do what I want. And I'm going to go do what I want and sell drugs where I'm not supposed to be. So at this time, I'm going to find and cause number, let's see, what do we have? Hold on. 26 DCCR 0340, find that you entered your plea of guilty freely and voluntarily. Find has sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of possession of a controlled substance. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23 DCCR 0390, going to find that you entered your pleas of true to count 1 and 2 freely and voluntarily. Find those counts true. At this time, find sufficient evidence to find you guilty of unlawful possession of a firearm by a felon. Find you guilty of that. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read it. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or how long that lasts, you can talk with Mr. All right, you can go back with the bailiff. Good morning. Are you Darius Derry? And will your client waive the formal reading of the indictment?
People, Your Honor.
Mr. Derry, in cause number 26 DCCR 0234, you're charged with the state jail felony offense of burglary of a building from December 17th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Derry is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of burglary of a building. Sentence you in accordance with your agreement to a term of 100 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've already been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right. Good luck to you, sir. You can go back with the bailiff. Hold on.
Okay.
Kevin Thomas. Good morning. Are you Kevin Thomas?
Yes.
And Mr. Thomas, in cause number 26 DCCR 0798, you're charged with a 3rd-degree felony offense and assault on a security officer from March 17th of 2026. Your indictment alleges that you were previously convicted of possession of a controlled substance, a 3rd-degree felony, August 28th of 2000. And then after that was final, you were convicted of burglary of a habitation, 2nd degree, September 29th of 2008. And then after that was final, you were convicted of possession of a controlled substance, a 3rd-degree felony, March 30th of 2021. 2 cases of possession of a controlled substance on that day. And what that means, sir, is that if you go to trial in this case and you're found guilty, the range of punishment would be that of a habitual offender, which means it would be a minimum 25 years in prison up to 99 years of life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Ms. Holmes that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on, it looks like maybe count 1 and count 2 to make this a 2nd degree for a 15-year term in prison. You have every right to reject that offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Mr. Coleman, is there any reason to believe that offer would change?
Not at all, Judge. And in full disclosure, while the 15 years is a formal offer, I did make a today only offer for less than the 15 if the defendant was amenable to that, and he's rejected that as well.
And what was that for?
I believe 10.
Yeah.
2.
So you understand, if you wanted to enter a plea of guilty today, there's an offer that was extended today for 10 years. Obviously, that's going to be off the table, as will be the 15 after today. Do you understand?
Yes, ma'am.
All right, so we'll get your case set on the trial docket. Mr. Thomas, Ms. Holmes has been appointed to represent you. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and we can appoint another attorney who can begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Ms. Holmes, you'll be released. Mr. Thomas, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff.
Thank
The proceedings demonstrate the court's careful distinction between substance abuse and drug trafficking when evaluating whether probation remains appropriate. Although the defense argued that structured supervision, treatment, and monitoring could help the defendant succeed, the judge concluded that the evidence reflected deliberate criminal conduct rather than addiction-driven behavior. Particular weight was given to the fact that the defendant resumed selling crack cocaine only weeks after receiving probation for a firearm-related felony involving drugs, firearms, and distribution-related items. The defendant accepted responsibility and requested another opportunity, citing his family, business, and personal goals, but the court found that these mitigating statements were outweighed by his rapid return to serious criminal activity. By imposing concurrent 8-year prison sentences in accordance with the plea agreement, the judge emphasized accountability, public safety, and the importance of respecting the conditions of probation. The case highlights that probation is a privilege dependent on compliance, and repeated criminal conduct can quickly eliminate opportunities for rehabilitation in the community.